Hello everyone. Welcome to today's Real Estate Institute of New South Wales webinar. The topic is National Employment Standards. We are pleased to welcome our presenter for today, Greg Patterson. Greg Patterson is the former Executive Director of the Real Estate Employees Federation. He's an experienced industrial advocate, negotiator, and employee relations advisor, having been involved in industrial relations at both national and state levels for many years. He was the 2013 recipient of the REI NSW Woodrow Waite Award for Outstanding Service to the Real Estate Profession. This webinar is live and interactive. You're encouraged to participate by posting questions to the presenters via the chat box, which is located at the bottom right corner of your screen. If you're experiencing difficulties such as loss of sound during the webinar, please dial 02-8267-0515. This number is also located in the chat box. Now, I'll pass you to Greg to begin the webinar.
Yes, thank you, Joshua, and welcome everybody to this presentation. What I'm hoping to do in the next 45 minutes or so is to paint a picture for you of the national employment standards that apply to employees throughout Australia. These particular standards are prescribed in the Fair Work Act and set out minimum employment conditions for all Australian workers. It's important to note that the national employment standards underpin any contracts of employment. They underpin, of course, the very fabric of the employment relationship, and any term of an award or a contract which seeks to undermine these conditions, of course, would be invalid. So it's very important to understand that these are the very fabric of any employment relationship. And there are 10 of them, and what I propose to do is just to quickly go through these one by one, just to identify what the topics are, and then we'll delve down a bit deeper into each of the 10 various standards. So the first standard is, of course, relating to the maximum hours of work that can be required of an employee. The second standard relates to flexible work arrangements. Third standard relates to parental leave. We then have the standard related to annual leave. The fifth of the national employment standards is personal carers leave and compassionate leave. We have community service leave, long service leave, public holidays, notice of termination and redundancy pay, and lastly, the 10th of the standards relates to what we call the Fair Work Information Statement. So that's the brief title, brief description by title of these 10 national employment standards. Let's go through them just in a little bit more detail, and then I'll delve down in a more intimate way in terms of each of those particular provisions. So, in terms of maximum weekly hours, the legislation prescribes that the maximum weekly hours of an employer cannot exceed a certain number per week, and that's 38 per week. We'll come back to that in more detail shortly. The second one relates to flexible work requests. This standard provides employees with an entitlement to request a change to their current working arrangements, and it also prescribes when an employer can refuse such a request. Parental leave sets the standard and entitlements and rules around the taking of unpaid parental leave, both for the birth of a child and for adoption. This should not be confused, of course, with the federal government's paid parental leave scheme. Annual leave, this standard sets an employee's entitlement to paid annual leave and the rules around the taking of the leave. Personal carers leave sets the standard in the entitlements for an employee to take paid and unpaid leave, and where the person is unable to attend to work for reasons of sickness or has responsibility for the care of a family member. And community services leave, this standard allows for employees to take leave, either paid or unpaid, and we'll talk about that in more detail shortly, to engage in community service activities and sets the rules around this activity. Long service leave, it's written into the legislation that the long service leave is an NES. It's a bit of a fallacy to the extent that it doesn't prescribe long service leave standards. Long service leave standards are still set in New South Wales by state legislation and in the ACT by their legislation. We're waiting for the federal government to eventually set a national standard that will apply to all workers throughout the entire country. But we don't know when that's going to happen. Public holidays. This sets out entitlements around being absent on a public holiday, as well as the meaning of what a public holiday is. Notice of termination. This is a very important standard. It sets out the minimum period of notice an employer must give an employee if they wish to terminate the employee's employment. Of course, there are exceptions to the notice, and that's where the person been found to have engaged in some sort of serious misconduct, in which case there may not be any notice, but we'll come back to that also. It also prescribes minimum payments where the employee is terminated for reasons of redundancy. And finally, the Fair Work Information Statement. This is a gazetted statement that provides the employee with some general information about his or her employment rights. And the standard requires that upon commencement of employment, the employer must give the employee a copy of this gazetted statement. So, having said that, let's look at each of these standards in a little bit more detail and drill down a bit further. So this is standard number 1, and this is the maximum weekly hours. Unless it's reasonable to do so, an employer must not request or require an employee to work more than, if the employee is a full-time employee, 38 hours, or other than a full-time, the lesser of 38 and the employee's ordinary hours in a week. If I could just simplify that for you, it means that if you've engaged someone on a full-time basis, the general rule is that you can't require them more than 38 hours. It might be reasonable in some circumstances to demand higher hours, but the general principle is 38 hours is the standard. If the employee is being engaged on a part-time basis or a casual basis, then unless it's reasonable to do so, they can't be asked to work more than the hours that they would ordinarily work in a week. The employee may refuse to work additional hours if they are unreasonable. And of course, the legislation sets some goals around how that might be interpreted. It sets some sort of benchmarks that takes into consideration whether there are work health and safety considerations, the personal circumstances of the employee, the requirements of the employer's business, and so on. But we don't generally see too many arguments or disputes around refusal, but if you do confront that problem, I would strongly recommend that you give us a call at the Federation and seek some further guidance. It is possible for an award to provide for averaging of hours of work over a period, and both the clerical and real estate awards provide such an averaging ability. Again, we don't see too much of that happening. The second National Employment Standard relates to requests for flexible work arrangements. Now, an employee is able, by the legislation, to request a change in their working arrangements if any of the following things apply. The employee has responsibility for the care of a child of school age or younger. The employee is a carer as defined in the Carers Recognition Act. The employee has a disability. The employee is 55 years of age or older. The employee is experiencing violence from a family member, or is providing care or support to a family member experiencing violence as described above. Now, this particular standard does cause confusion, and it does generate questions from members. But keep in mind, whilst this is a standard prescribed in the Fair Work Act, employees have always had the ability and the right to go to their employer and ask for a change in their working arrangements. And the employer would generally, in those circumstances, consider the request. even in an informal sense, and then may have responded yes or no to that request. But what this does, of course, is to legislate that particular right of an employee to seek a change. And I think what we need to be careful of here is that we don't interpret that to mean that there's an automatic right for the request to be granted. It is a request. It's not a right to change. It's a right to request. And I emphasise that point because we do see many employers of the belief that they have to acquiesce to the request. Now, an employee must have 12 months continuous service, either full-time or part-time, or be a long-term casual before making the request. Now, long-term casual is defined as someone who has had 12 months engagement as a casual and an expectation of ongoing employment. The employee must set out the request in writing and set out the reasons for the change. If someone was to walk into your office and say, look, I'd like to change my arrangements from full-time to part-time, or I no longer wish to work on Saturday, I'd like to vacate my Saturday shift, then they should be encouraged or asked to set the request out in writing, as well as the reasons why they want that change. Because we need to confirm that the reasons for the change conforms with those reasons that are listed in yellow on this slide. Your obligation as an employer is to respond to that written request within 21 days, either granting or refusing the request. Now, in terms of granting, that's obvious, that's fine. The employer accepts the request and changes will be made accordingly. The difficulty, of course, arises when there is to be refusal of the request and what can be the basis of the refusal. Well, importantly, refusal can only be made on reasonable business grounds. That's what the legislation prescribes, and that includes things to do with the cost that would be incurred by making the change or agreeing to the change, the efficiency in customer service, the effects on customer service, the impact on other employees. If you were to change one person's working arrangements, will that necessitate changes elsewhere within the business? And would that have a negative impact overall? Well, that could be a basis for saying, we're sorry, we can't agree to that request. So the strongest advice I can give people viewing this webinar is, if you are confronted with a request of this nature, you should contact us at the Federation and seek guidance, and particularly where you believe that the request is going to have a negative impact on your business. The third of the standards is parental leave, and I'd have to say this is by far the most technically complex of the 10 standards. It's very prescriptive, and there's lots of twists and turns that can occur in terms of questions from members to the Federation around this topic, around this issue. But I'll cover it off in terms of what the legislation says, but the practical application often needs to be discussed individually to get the right answer. But in essence, the parental leave provision provides an entitlement to full-time and part-time employees must have completed at least 12 months service, and the casuals are slightly different. We won't go into that particular issue in this webinar. But the leave must be related to the birth of a child or the employee's spouse or de facto partner. So, a female employee will be taking the leave for the purposes of giving birth, or a male employee may decide to take parental leave for the purposes of being the spouse or de facto partner of the employee who is giving birth. And it also relates to the placement of a child for adoption. But it is important to note that the reason for the leave must be to have responsibility for the care of the child. The leave, in essence, is 12 months, of unpaid, I emphasise unpaid, parental leave in a single continuous period. And the reason I'm emphasising the unpaid is that there's often some confusion amongst people, amongst employers, about this NES standard and, of course, the paid parental leave scheme introduced several years ago by the federal government. They are different schemes completely. In terms of notice, we recommend, it's not mandatory, but we recommend that employers advise employees of their rights and obligations, setting out exactly what the employee must do in terms of giving notice and so forth relating to the leave. And on our website we do have a standard template form that you can download to meet what we consider to be best practice in this regard. In terms of notice, the employee must give written notice at least 10 weeks before commencing the leave. It should state the start date and the end date leave. This, unfortunately, is often neglected when notice is given. They'll often say, I intend taking parental leave for the birth of my child. Always state specifically when that date will start and when it will end, and you are entitled to have those dates presented to you. Any changes to the dates must be confirmed at least 4 weeks before the intended start date. That can be changed by the employee as long as it conforms with that 4-week time frame. Within the 6 weeks prior to the expected date of giving birth, the employer can require the employee to provide some medical evidence to support their fitness to continue working. Again, this doesn't happen very often, but there have been occasions where for one reason or another the employer has been concerned about the employee continuing to work, and they want to make sure that the employee is deemed fit by a medical practitioner to continue to perform their duties. If the employee, the employer can require the medical certificate to support the fitness to work. If the employee wants to work, they need to provide a medical certificate stating that they are fit for work. If no medical certificate is provided, then 7 days after the request, the employer may require the employee to go on unpaid parental leave. Now, again, I'd say that happens very, very rarely, but this is a description of what the legislation provides. In terms of extending leave, well, the employee can extend his or her leave by giving at least 4 weeks' notice. The employee may request a further leave period of up to 12 months. In other words, they could, if you grant the request, they could have 24 months or 2 years off work on unpaid parental leave. It's been very, very rare to see an employer in this industry, from my experience, to see an employer extend that period beyond the 12 months. You have to have reasonable business grounds for refusing it. And, generally speaking, in our industry with small-based employers, small micro businesses, it's not that difficult to really find reasons as to why you just can't extend that unpaid parental leave for another 12 months. Reducing the leave. If the employer agrees, the employee may reduce the period of unpaid leave after commencement. So if they said, for example, I told you before I started leave I would be off for 10 months, I'd like to come back after 6, then that could only be accommodated with your agreement, with the employer's agreement. And there's a reason for that, of course, that you have taken steps probably in most circumstances to replace that employer, and you may have got a temporary replacement in, and you've guaranteed them or told them that they'll be there for the 10 months that the person will be away, well, I think it is designed to say, well, look, you need to fulfil that commitment to that temporary employee, and therefore the employee could only reduce it with your agreement. The employee may take other forms of leave, excluding, of course, personal carers leave. They can't take sick leave in conjunction with parental leave, but they could take annual leave whilst on maternity leave. And this normally would occur at commencement, so they might start the leave in effect by taking 4 weeks or 5 weeks or whatever leave they've got accumulated, because they want the pay. And that's permissible. And indeed happens quite regularly. This doesn't extend the period of unpaid parental leave, so if it's taken in conjunction with it, then it's still only 12 months. Keeping in touch days are permitted, so the employee during the course of the unpaid parental leave is entitled to come back for a maximum of 10 days during the course of that leave. They call it keeping in touch days so that they can see what's happening and maybe do a few duties that are required of them. Of course, those days where they come in, or the hours that they come in, would be paid hours. So that was a change that happened a few years ago, which I think was a positive change. Other entitlements, well, there are entitlements to unpaid special maternity leave because of illness. There is a provision in there which deals with the transfer to a safe job. So that, for example, if someone was a salesperson, pregnant, and was suffering from gestational diabetes and was unable to drive a motor vehicle, then they'd be highly unlikely to be able to fulfil their duties as a sales. Then there is a requirement to transfer them to a safe job if they are able to work, as opposed to someone who's too sick to even come to work. That transfer to a safe job may be with or without pay. The transfer, of course, would be to a job on the same terms and conditions, but if you don't have a safe job, then there may be a right for them to take no safe job leave, which would be paid leave. Now, of course, the key focus, the key element of parental leave is the return to work guarantee, and this provides that on ending the period of leave, the employee is entitled to return to their pre-parental leave position, or if that position no longer exists, and that does happen from time to time, an available position for which the employee is qualified, nearest in status and pay to the pre-parental leave position. Replacement employees, as I mentioned a little bit earlier, you'll probably want to find someone to do the job of this employee who has proceeded onto parental leave. Now, the replacement employee must be advised that the engagement to perform work is temporary, and of the rights for the employee to return from leave, that should be, early, and of the rights of the employee to return from leave early in certain circumstances. So that needs to be made known to the replacement, and we do have a template letter on our website, which again you could use for the purposes of engaging a temporary employee. Annual leave, other than casuals, for each year of service, employees entitled to 4 weeks of paid annual leave. Of course, casuals don't get annual leave. It's paid, they get a loading, a casual loading, which encompasses the annual leave payment. Sorry, I rephrase that. They get a loading which compensates them for the fact that they don't get annual leave entitlements. This amount of leave, the 4 weeks, accrues progressively. So in days gone by, of course, they didn't get the 4 weeks until the end of the year. Now, of course, it accrues progressively throughout the year. It accumulates from year to year. So if the employee only takes 2 weeks of annual leave in any 12-month period, the 2 weeks not taken will accumulate into the next year, and so on. The employer must not unreasonably refuse to agree to an employee's request to take accrued leave. This does create some disputes around employers wanting to say no to the requests from an employee to take leave. Again, I would strongly suggest that where this occurs, advice should be sought, because each case will stand on its own set of facts and circumstances. Your refusal of the request needs to be reasonable, and so we would need to associate the reasonableness with business, the operational needs of the business. For example, the best example I can give you is someone walked into your office today and said, look, I'd like to take a week's leave starting tomorrow. It might be reasonable to say no, because it's you haven't given appropriate, or not appropriate, but you haven't given sufficient notice for us to take steps to accommodate that absence. And it's just so many different permutations across this particular issue that advice ought to be sought if there's any doubts as to whether or not you should or should not agree to the request. It's one of the reasons why we strongly encourage employers to insist that their employees, that their staff fill out a leave request form, so that the request can be given consideration, and if refusal needs to be made to that request, it can be done properly. The employees taken not to be on annual leave when the day that they're off is a public holiday or a part-day public holiday. If the leave period includes a day of any other leave. Now, this is a little bit controversial, but for example, if the employee was on annual leave and they brought in a doctor's certificate to say that they were sick on a day that you thought was annual leave, then the annual leave would have to be recredited and the absence would be treated as personal carer's leave. As I said, fairly controversial and one that we're not overly happy with, but that's the way the legislation has been interpreted. Annual leave is paid at the employee's base rate of pay, so it's not paid to include allowances, bonuses or anything else. It is based only on their basic rate of pay. On termination, of course, any untaken annual leave must be paid to the employee. Continuing on with annual leave, there are certain entitlements that will apply for transferring employees when a business is sold, and it's important that if you were selling a business, buying a business, or selling or buying a rent roll, for example, and there were going to be transferring employees, that you understand those rules. I won't go into that here, but guidance ought to be sought. We very recently, only a matter of a few weeks ago, had the Fair Work Commission hand down a very important decision which has inserted into all modern awards some cashing out provisions. And there are limits to the leave that can be cashed out. There's limits to the leave that must be maintained in the accrual bank of the employee, but at least now, for the first time, it is possible for an employee to ask their employer to cash out a couple of weeks' leave each year, providing they maintain at least 4 weeks' leave in their balance. So we've written to members about this, and I think this will be a real benefit for both employers and employees, because the accrual of the annual leave liability on the balance sheet of businesses can be quite significant, because our industry is one where, from my experience, employees don't take all of their leave entitlements over a 12-month period, so the accrual banks up, adds up, and suddenly on the balance sheet you've got this massive liability sitting there. Well, now it is possible for employees to at least buy out some of that liability, which will ease that balance sheet problem. There is also the ability, courtesy of this recent decision, to force employees to take excessive leave. Again, there are limits and controls on this, but in essence, excessive leave is where leave has accumulated more than 8 weeks. And where that has occurred, then there are certain rights for you to insist that the leave is taken and bring it down to that 8-week level. The next one is personal carers leave and compassionate leave. Now, personal carers leave for a person of my generation, of course, we used to call it sick leave. But now it's more than sick leave, because sick leave was, of course, where the employee was sick. And now we've got a thing called personal carers leave that applies. But I just wanted to use that term sick leave because it's still a term that a lot of people understand, and it's still a term that a lot of people use. And I find it very difficult when I'm talking to members to get my head around using the term personal carers leave, and I'm so used to using the term sick leave. But it is what it is, and it says that other than casuals, of course, again, like annual leave, casuals get paid a loading to compensate them for the fact they don't get sick leave. For each year of service, the employee is entitled to 10 days of paid personal carers leave. This amount accrues progressively, like annual leave, throughout the year. It doesn't just suddenly appear at the end of a period. It accrues each week of the year as a certain number of hours towards their personal carers leave entitlement. It can be taken because the employee is not fit due to personal illness or injury. That is what I would have called the old sick leave description. But of course now you can take the personal carers leave that's accumulated or accrued to provide care or support to a member of an employee's immediate family or household due to the personal illness or injury of the member of the household or an unexpected emergency. So the most common example of this is where an employee has to stay home to care for a sick child. They are entitled to do that if they are the carer, to provide care or support to that child, because you can't send them to daycare, you can't send them to school, so someone has to stay home and look after them. Then they're entitled to use their personal carers leave accrual for the purposes of being paid. The employee is not taken to be on personal carers leave on a day that's a public holiday. It's paid at the base rate of pay, so again, no allowances are payable on a period of personal carers leave. There is, if a person hasn't got any personal carers leave, paid personal carers leave accrued, or they've run out of it, then there is an entitlement to unpaid personal carers leave up to 2 days on each occasion to provide care or support to an immediate family member. Compassionate leave is a bit different. Compassionate leave is really the new term that's used in awards to replace the old bereavement leave, so that people can have up to 2 days of paid leave upon the death of an immediate family member or a member of the household. It goes a bit further than just the death, because now an employee is entitled to access compassionate leave where the family member contracts a personal illness that poses a serious threat to his or her life, or sustains a personal injury that poses a serious threat to his or her life, or if the individual in fact does die. So it could be that the employee takes 2 days of compassionate leave upon an employee, an immediate family member, contracting some serious illness. They would also be entitled, if that serious illness led to the death of the person, to take a further 2 days of compassionate leave. It is paid at the base rate of pay. What are the notice and evidence requirements? Well, the employer is entitled to notice of the absence as soon as practicable and to be advised of the likely period of absence. Now, this is really a policy decision that your business should consider and implement as to who they notify, when they should notify, and so forth, but legislation says as soon as practicable. If you do require, they must provide evidence that would satisfy a reasonable person, and emphasise those words in yellow, that the leave is taken for a reason specified under the standard. So um, if you have a policy as part of your company policies and procedures that states, for example, as we've seen on many occasions, that says you must provide us with a doctor's certificate for each and every absence. There's some question marks as to the legality of that, because it might be unreasonable to expect, it might be unnecessary for a reasonable person would not expect that they would have to provide you with a doctor's certificate for each and every day that they have off work. You've got to take a sort of pragmatic, sensible approach to it. If you're not sure as to how this should be treated on a practical level, please give us a call and we're happy to discuss it with you. But yeah, sure, if there are circumstances where employees are absent for a number of days, then it would be very reasonable, I would have thought, to expect a doctor's certificate. Or if you think that someone's taking every Monday or Friday off and that there's something suspicious about it, well then it might be reasonable to expect that they give you a doctor's certificate. But each case has to be assessed on its own set of facts and circumstances. Community services leave. This is where the employee is entitled to time away from work when engaged in an eligible community service activity, and that's defined as basically jury service or some form of emergency management activity. Now, the employee must provide notice and evidence associated with the absence. So if they've got a jury service summons, they should be able to provide you with that. If they're participating in some emergency management activity, they should also be able to provide you with some evidence around that activity. Again, we don't see too many problems arising from this. If there's a bushfire happening or a flood happening in a particular location, people are aware of it. They usually make their membership of voluntary associations well known, so it's unlikely that they'd be taking advantage of the provisions. But there are still requirements for people to provide evidence if necessary. Payment at the base rate is only in relation to jury service. So if someone was taking community service leave for the purposes of participating in some emergency management activity, such as a fire, bushfire, or a flood, then they wouldn't be entitled to request or demand payment for that absence. The only occasion where it applies is for jury service, and the payment's limited to 10 days of jury service. Of course, if they are paid, and they usually for attending jury service, you would only have to pay the difference between what the court provides the employee and what they would ordinarily have received as their base rate of pay. Long service leave, well, it's, as I mentioned a little bit earlier at the start of the presentation, there are no national standards yet, but the standard in the Act basically, bring it down to its simplest description, the Act provides that we refer back to the Long Service Leave Act 1955, which is the New South Wales piece of legislation, to get our standards in terms of long service leave, until eventually at some stage the federal government decides to enact legislation across all jurisdictions. But who knows when that's going to happen. For New South Wales employers, this means that the employee is entitled to long service leave after 10 years of continuous service. Please note, 8.67 weeks is the entitlement. There is, in some circumstances, an entitlement to pro rata long service leave between 5 years and 10 years in limited circumstances. The three main reasons are: the employee is dismissed by the employer for reasons other than serious misconduct, or if the employee dies, or if the employee resigns due to illness, incapacity, or pressing domestic necessity. Now that last entitlement there, where the employee resigns because of illness, incapacity, or pressing domestic necessity, has often been the subject of judicial interpretation. It is often viewed as favourable to the employee. Reef has run cases arguing that the employee was not entitled to it. for whatever reason. Illness is usually the contested one. I could talk about this for ages. I can't. So all I can say is if you have some sort of problem about whether or not an employee is entitled to pro rata long service leave, that is where the employee leaves the employment between 5 years and 10 years, please give us a call and we'll talk through it and see what the best response should be. It's paid at the employee's ordinary pay as opposed to what we were talking about with sick leave and annual leave at the base rate. So ordinary pay under the long service leave legislation includes average commissions or bonuses. If accrued long service leave entitlement is not taken during employment, it is paid out on termination, same as annual leave. Where an employee transfers upon the sale of a business, there's also an entitlement to long service leave to be transferred. And some businesses, fortunately not too many, but some businesses have got caught with this. They didn't understand that when they purchased the business and employees were also transferring with that sale, that they had to assume the liability for the employee's long service leave entitlement. There should be some consideration in the purchase price or other ways of managing it. So if you are thinking about selling, thinking about buying, please make sure you talk to your solicitor or talk to us about the potential liability here. Public holidays, employees are entitled to be absent from work on a day or part day that's a public holiday, and that can be a public holiday declared by the Commonwealth or by the state. An employer can request an employee to work if the request is reasonable. An employee can refuse the request if it's not reasonable or the refusal is reasonable. So again, there are some guidelines in the legislation around this, but again, just to be brief about it, I suppose one of the two key elements have to come into play here is, firstly, the amount of notice that was given for the employee to work the public holiday, whether there be extra pay for the employee to work on the public holiday, whether what are the commitments of the employee or the responsibilities of the employee that might be affected by them working. That would generally be family responsibilities, of course. And of course, what are the requirements and the expectations of the employer in this regard? So it's a little bit complex, and again, advice ought to be sought if something happens that causes a dispute. Notice of termination and redundancy. Okay, well, the employer must not terminate an employee's employment unless the employee written notice of the day of termination. And the amount of notice depends upon the length of continuous service. Now, I emphasise, please, that it's written notice, not verbal. So it's very important that if you are going to terminate the employee, you have the conversation and you say, look, we're sorry, but we've decided that it's not working out for one reason or another and we're going to terminate your employment. That's fine. There's nothing wrong with that. In fact, that's the appropriate approach. But that ought to be followed up immediately with, or shortly thereafter with, the written notice. And that notice is in that table. So if the employee has not been there less than a year, you have to give 1 week. Between 1 and 3 years, it's 2 weeks. Between 3 and 5, it's 3. And more than 5, it's 4. There is, of course, an additional week if the employee is over 45 years of age and has completed at least 2 years' service. Now, I think it's very, very important that I emphasise here, this table that I've just shown, that previous slide, is not to be confused with the obligations under the award that relate to resignation by the employee. We're talking only here about termination at the initiative of the employer. There's a whole separate standards that apply, particularly for operational employees that relate to notice if they are going to resign. That's not a standard, so I won't go into it in this particular presentation. Redundancy pay, well, redundancy is where an employment is terminated because, one, the employer no longer requires the job to be done by anyone, except in relation to the ordinary and customary turnover of labour, or two, employer bankruptcy or insolvency. Now, just in terms of that part in brackets in Roman 1 there, exception for ordinary and customary turnover of labour. So you don't pay redundancy if you're sacking somebody or terminating somebody because of performance-related matters, conduct-related matters, things of that type. It's where you no longer require the job to be done by anybody. And B, that if you had a contract, for example, to manage a building, some of our commercial members obviously may have tendered to provide building services for a commercial or strata building, and you lose that tender through a tendering process. It may well be that you no longer have a requirement for someone to perform the job, but it might well be that fits the category of ordinary customary turnover of labour, and therefore no redundancy would apply in the circumstances. Redundancy pay, there's a scale in the Act of the pay you have to give, and in the scale goes from 4 weeks, where the person's been there for at least 1 year, up to 16 weeks, where the person has 9 years of service. It starts to drop back after 9 years because the legislation recognises that the employee would also be entitled to long service leave. There is an exclusion from paying redundancy where the employee has less than 12, the employees who is being made redundant, or the position of the employee is being made redundant, if they have less than 12 months service, there's no pay. Or if the employer is a small business employer, there's no severance pay, there's no redundancy pay. So a small business employer, just to remind people, is of course a business with 14 or fewer employees, fits that category. So when people ring us and ask us about redundancy, the first question we'll ask is how many employees have you had? How many employees do you have at the time that this position is being made redundant? And lastly, the Fair Work Information Statement. This is a standard government form, as I said at the commencement of the presentation, that must be provided by the employer to every new employee as soon as practicable after commencement of employment. Again, you can get this off our website, and it's also in our workflow and checklist in our people management system. The induction workflow and checklist has access and links off to the statement for you to print off and download and give to the employee. Now, look, it probably doesn't sound a terribly important standard, but where we see this having impact is where there's a dispute with the employee at some subsequent time in the relationship, and there's an investigation from, the Fair Work Ombudsman, and the first thing they might ask you is, okay, when did this person start? Give us their details of commencement, and show us where you can prove that you gave them a copy of the Fair Work Information Statement. And if you can't do that, then you're on the back foot before you can look at the dispute. And it's such a simple thing to do. We think that it's very important that you understand this, recognise it, and just take those steps at the time that you put a new staff member on. Where do we see most problems? Well, in terms of flexible work arrangements, the most problems we see is knowing when and how to say no to the request. In terms of annual leave, the imperative of keeping annual leave records. Crikey, I've seen quite a few cases over my 23 years in this industry where we've needed to see records of annual leave because there's been a claim around it and the records don't exist. The best example of that is really for commission-only employees. Employers think that because they're commission-only, there's no requirement to keep records. There is, very much so, requirements to keep records. Probably more particularly for them than any other employee. So please, if you take nothing else out of this webinar, it's that you must keep annual leave records in relation to all of your staff. We encourage you, as I said earlier, to have leave application forms that you make employees fill out each and every time they wish to take a day's leave. We see difficulties around refusing annual leave requests. People don't like to say no. Understand that. And it may be possible that you can, but recognising, of course, that you can't unreasonably refuse the request. In terms of personal carers leave, paying for personal carers leave before entitlement has accrued. Once you've paid it, you've paid it. It's not, not an infrequent question where members say, oh, person's leaving and I gave them 2 days of sick leave that they weren't entitled to. Can I now deduct that back out of some other payment on termination? It's paid, it's gone. So if you're going to pay it, understand that. And a lot of people do that, and that's not a criticism. But it's difficult once you've paid it to then try to seek to recover it, once it's been given. And finally, the evidence thing is always a problem. What is satisfactory? Well, what is evidence that would satisfy a reasonable person? Again, each case has to be assessed on its own set of facts and circumstances. Parental leave, confusion with the Commonwealth paid scheme, I've mentioned. How to go about filling the temporary position, what needs to be done. Again, all I can say there is it's very important that the temporary appointment is made aware of the fact that it is a temporary appointment and not a permanent appointment. Arrangements, we see problems when the arrangements are not confirmed prior to leave commencing. Questions will be asked by members to us of an issue around parental leave, and you ask, when is the employee due back? Oh, we don't know. We think it's going to be sometime whenever. That ought to be clear in your mind as to when that employee will be back at the workplace. And of course, what happens with employees with less than 12 months service? There's no entitlement to parental leave. But what do you do if the employee says, well, they've started work with you for 6 months, they've been there for 5 minutes, and they announce that they're pregnant, and everyone goes, woohoo, great, fantastic, congratulations, but what are you going to do about leave? I take parental leave. Well, sorry, but you're not entitled to parental leave. We see issues around this, and unfortunately, it's not an easy black and white sort of response, because if you were to say, well, sorry, you've got no parental leave, you'll have to resign, then you've got discrimination issues that come fairly and squarely into the frame. So, again, please give us a call and discuss it. But it may well be that the outcome's going to have to be allowing the employee to take a period of agreed, just unpaid leave without pay. They don't have the statutory right to the 12 months and all the other things that go with it, but it might be appropriate to say, well, look, we'll grant you a period of 3 months or whatever, unpaid, just leave without pay. And finally, notice of termination. Well, biggest issue we see here is that it's not given in writing. And that is just so critically important that it is given in writing. Confusion with the notice. As I mentioned again in my commentary earlier, confusion with the notice the employee must give when resigning. The standard, the NES standard, relates to the employer-initiated termination, not the employee-initiated termination. And of course, misconduct avoids notice, but a lot of people like to give their own description and definition of misconduct. Law is a little bit more complicated than what a lot of people believe. If you're going to try and avoid paying notice to someone because of the conduct or the misconduct of the employee, it needs to be conduct that is so serious that it's not reasonable for you to continue that relationship beyond that particular point in time. And the courts have often looked at this, and so therefore guidance is best sought. So that covers, hopefully, succinctly but in a fairly detailed way, the 10 national employment standards. And Josh, I was wondering, do we have any questions that we'd like answered before we call it quits?
Yeah, we do actually. We have 3, 2 from Jacinta Kelly and 1 from Suzanne Wood. We'll go with Jacinta's first.
Yep.
So Jacinta's first question was, is the request for flexible work arrangements only for temporary changes, or can it be permanent changes?
It's generally meant for permanent change. but I can't see anything that prevents the request being a request on a temporary basis. But it would have to be agreed. So, but it's generally the concept is generally associated with a permanent change.
Right, okay. She'd also like to know if personal carers leave is included in general sick leave or extra.
No, I think I probably went over this in a fairly detailed way in my commentary, that personal carers leave is just the contemporary name that's given to include what we used to call sick leave. Sick leave is not something additional to it. That is it.
Yeah. Right, excellent. So Suzanne Wood would like to know, what if an employee decides they don't want to return to work after parental leave?
That's certainly permissible, and that certainly happens not infrequently, where the employee has applied for leave, been granted leave, and has proceeded on to leave, had the child, and is discovering that for whatever reason she doesn't wish to return to work. Then, of course, then she can resign, and there's no negative results for that employee. That's just the decision that's taken. She would need to give, obviously, written notice, or should give written notice of the intention not to return, and you'd like to think that notice would be given as early as possible, so that the business can make the appropriate take the appropriate steps to find a replacement. But yes, that's certainly available to the employer to decide. I'm enjoying this motherhood thing, staying at home thing, and hard work, but I prefer that to going back to work, or whatever else, whatever factors come into play. That's certainly possible.
And so that also applies for male employees as well?
Yes, there is the capacity for male employees to also take a period of parental leave. There is the capacity, there's limited capacity for both the mother and father to be off at the same time, but that's not extensive. There's a limited period of 8 weeks where that can occur. And again, best to get some guidance if you're in any doubt as to how that's to be applied.
All right. Okay, so thank you for participating in our webinar today on National Employment Standards. Please complete the survey at the end of the webinar, as REI NSW values your feedback. Thank you.